Okay, welcome everyone. This is Grant Abbott speaking. I've got another platform update, and this is going through our LightYear Docs Discretionary Trust, which has really been purpose-built by the auditor the author and the legal counsel who took Bamford right from the start up to the High Court from the AAT. And it's quite interesting because it dealt with a streaming of income to the Seventh-day Adventist Church. And of course, you can imagine the Commissioner wanted no part of that one, given the fact that they were a tax-exempt entity. And it ended up going to the High Court, and it's quite interesting to read all the judgments all the way along the track. And it certainly shows the power of a well-constructed, well-drafted and well-authored trust deed or discretionary trust deed, which obviously we want to try and keep in the family if it is possible. Otherwise, we'd end up using a fixed trust. We have to bear in mind, look, I think we need to take a deep breath as most of us would have family trusts ourselves or discretionary trusts ourselves for our business or to a lesser extent investment income. I think most of us would have that in an SMSF, but it's good to actually play the field because whatever's in the family SMSF family SMSF is locked up until obviously you meet a condition of release, whereas in a family trust, we can make a corpus distribution or an income distribution at any point in time, which is absolutely crucial. So family trust gives us the flexibility, but family SMSFs gives us the beautiful low-taxed, hopefully no-taxed compound growth environment. And really the way I see it is we need to understand how they both work together, interplay together. Ideally, if someone came straight into your offices and said, look, I want to set up a business, then clearly you're going to set up a company, you're going to set up a trustee company, a family trust, probably a bucket company as well. Ideally, I'd be doing that. And also an SMSF and the trustee company of an SMSF. So that would generally cost quite a bit, but it seems to me it's a opportune equation, and particularly if the client has already got some money in the retail or industry fund. I'm not sure for those of you who were on the seminar yesterday, but it was reported in the SMSF Advisor magazine that I've had a bit of success actually getting both industry and retail funds to pay out benefits really quickly. Provided you've got your compliance certificate for SMSF, I can guarantee rollovers within about 1 or 2 days with a very nasty email. So if you come up against that, you're part of our community, please feel free to contact me and I'll shoot you the exact email that was used for Ashley to get her benefits out of MLC within the space of 6 hours. After she was told she had to go and see an MLC advisor because of the risks of a self-managed super fund. Don't you love them? Very, very, very scurrilous people. If we have a look at, so let's go through and I've got a couple of questions, so I'll come back to those questions a bit later on. Now, what is typical is this is not just a key platform update, it's also I'll go into the document itself and how to build it, but we need to go through the background and the strategy, etc. Before I do that, I'm not sure if you're aware we've got new pricing packages. If you're on a LY basic, then obviously it's $99 per doc, which compared to our competitors is, I think the next one we have with Clear Docs is probably $149. But on a doc-by-doc basis, we've kept the pricing low. We have got the best quality documents because everything is authored in-house. We don't need to pay a commission or a fee to a legal firm. Everything is authored and signed off by TJ Legal, which I'm a specialist consultant with. All the SMSF documents are written by me personally. So you're getting the best of the best. For example, the latest SMSF deed I've done, it's now my 5th deed. And of course, you'd think I'd know something by now. It's not a Band-Aid document. One of the ones, though, is I'd really challenge you to take up the unlimited document offer. If you're only just a very small single practitioner or family, a family financial planner, then it might be a little bit much for you. But definitely for accountants, the $5.95 per month and unlimited documents. I don't care whether you do 1,000 documents or whatever. The key about that is, one is we've got the engine, you'll talk about that later, can actually do 1 million documents an hour. So we don't really mind how many documents you do, but it is scalable. So it doesn't end up breaking, which is fantastic. So we'll go and show that a little bit later. But with the unlimited documents, the key is, for example, for those of you who were on the session last week, the key ones for us at the start of the year is an employment agreement, investment strategy, and also pension payment. Absolutely, that's crucial, vital for compliance. Now, the hard thing about that is explaining that to the client that, look, we need to do an investment strategy, we need to do this, we need to do that. And then you've got to jump on our platform and pay $99, or for some others, for example, pay $200. Whereas it shouldn't be the case. You should be able to do those and not have to go out of pocket. So everything's encapsulated within your one cost. And really $5.95 a month is you only need to do like 2 or 3 specific documents for that a month under other platforms, and you're way off and running. Remember, ours has got a lot of strategy, automation, etc. So, but the main thing for me is the weakness I find in all SMSF advisors and also tax and accounting practices is the lack of documentation. And simply the barrier to that has been the cost of providing that document for the client. So I think we can all lift our game, and to do that, obviously the $5.95 is great. Or if you want to get the unlimited CPD as well for all your staff around SMSFs, up to 30 plus hours a month. Oh, sorry, a month, that'd be great. A year, in fact, I've done about 6 hours this month. Effectively, then just pay $7.95 a month. Okay, so there's nothing short of magic when we actually look to our discretionary trust. So the family trust has been the best example of using the family to minimise tax and also maximise wealth. In terms of that, we've found that we can obviously stream income. We can stream income to retirees. As long as someone's got a heartbeat, we can stream income to them. Obviously, there's a concern there in terms of streaming to children or minors under the age of 18 because of the penalty tax rates. So a better way of doing that is to, again, obviously not young, but to get them genuinely employed by the family trust, and then paying them a fee for that. Now, 2 sides of that. If they're genuinely employed, they can only get paid for the work that is specifically completed. From the other side is if it goes over into an SMSF, there's no limit on the amount of contribution that can be made in reference to the work there. So what we do is, this is where they both work side by side, the family trust and the family SMSF, and that becomes that part of that whole business unit. For those who are strategist members, I did a really good SMSF advice business, or what I suggest is the best SMSF advice business session yesterday. So you can jump online and get that, or contact us at support@ilovesmsf.com to get that particular video. Now, of course, we can stream income, and that's a part of the Bamford decision, Bamford versus FCT up in the High Court, is that we can stream, for example, franked dividends, capital gains. But I'll go into, when we get in the document, we'll actually go through that. If we do go to older members of the family, and it's not a bad idea, we just have to watch out, obviously, for age pension or Centrelink issues. And it's quite useful because if we have a look at clients who primarily, if we've done the right thing, and they're living off their self-managed super fund, so they're receiving either lump sums or pensions, that is neither assessable income nor is it exempt income. So it means that if we stream down to them, let's say we just stream ordinary income or business income, then what will happen is effectively they'll take at the marginal tax rates. And remember, we've got a new uplifted marginal tax rates, our threshold, plus there's the low income tax offset and the low to middle income tax offset. So you can stream out of that family trust, I think, around about $40,000 to $45,000 tax free to those older parents who are living on tax exempt income from the super fund. But we do have to watch out, obviously, for age pension and or Centrelink issues. So that's crucial. But we can go up, But again, if we're looking at minors, the preference there is actually to get them employed rather than distributing to them because of the penalty tax rates. And of course, we've got our bucket company, which is de rigueur for when we set up a discretionary trust. We want to make sure that we can distribute to a bucket company. For that, if it's investment income that's going in, then effectively the tax rate is 30%. And obviously, if we've got a 30% tax rate, when we pay out dividends from the bucket company, effectively it will come with franking credits, which is not a bad idea. And I'll talk about that a little bit later on when we go further into streaming and SMSFs. If it's business revenue, then it's actually, it should be 27.5% for business revenue where you're less than $10 million. So there's a bit of concession there for business revenue. I've got a couple of questions from you, Mesh. I'll come back to those later on when I go through the actual documents so that we can go through what a leading member discretionary trust is. So if I have a look through that, if we go through to the next one, as I said, the best thing to do is to bundle it up with a family SMSF and a family trust. So the benefit is completely different. As I said, with a family trust, we can spread it across all our beneficiaries. So that includes obviously anyone, family, cousins, so on, stepchildren, whatever, and use their personal tax rates. With an SMSF, it's a little bit different because if we do, for example, stream, and by the stream, there's three ways of doing it. First off, making a distribution to let's say a retiree, and then they make a personal contribution into the fund. So that's one way of doing it. Another one is getting them employed genuinely. As long as you can show employment, as I said before, there is no limit on the contribution can be made compared to hours work. There's a commissioner's ruling on that. I think it's TR 2005/8, 2005/8, and there's no anti-avoidance rules in relation to that. So if we do that, then again, we've got a different scenario. And the final one is obviously distributing directly from a family trust or discretionary trust directly into an SMSF or into a state, and I'll cover that a little bit later on. The benefit, the difference between all of those is obviously in a family SMSF. We want to make sure that when we do stream or transfer or do whatever, that effectively it's going to people who are already under a condition of release. So, for example, as I said before, we could have a 14-year-old who's genuinely employed by the family trust. We've got an employment agreement, so this might be a farm. They come and work, when they come back and work on the farm. The family trust can obviously employ them, but if they're only doing minor work, you can't pay them more than what they're worth. But in SMSF, you can actually add, say, $50,000 contribution to them. Now, the problem about that, that's okay. It's tax effective because that obviously is taking income out of the discretionary trust and putting it into an SMSF. What we've got there is a couple of things is that first, if it's over the cap, there's $25,000 excess concessional, which will actually be streamed or added back to the member's assessable income. Now, I'd have to go and check that one, but I'm pretty sure that is not subject to the penalty tax rates because it doesn't come from a trust per se. It comes from is pursuant to a contribution in SMSF, but I will check on that one. In fact, I've never thought about it until then, mainly because for a 14-year-old to receive that sort of amount of money, it's going to be locked away for a long time. But, if you've got excess contributions, it's probably not a bad idea to get them started. The best time to put money into super, obviously, is earlier on. But for retirees, look, I've talked about this a long time. I've got quite extensive case studies on this. I will be going around Australia in October, doing a lot of estate planning, leading member, Umesh, for discretionary trusts and also SMSFs, bucket companies, trustee companies, etc. So that's quite a separate ways and means. From that perspective, what we end up doing from that is it'll be around October, I think the 15th around Australia. So make sure you come along for that because not only will I be able to teach you, but it'll be a rollout of our complete estate planning solution, which include wills, testamentary trusts, and I'll talk about that anyway. I'll wait that for a later stage. But with a retiree, if again we're subject to our contribution limits, the SMSF party is getting very close to verifying its 500 members who are on the roll and who are also not members of another party. So once that gets up and running, and we've just got to make sure we have to hand pick all of the relevant people. So when it goes in, it can't be knocked back by the AEC. What we'll do from that perspective is one of our planks is that contributions for over 75 should be allowed. There should not be a limit on people over 75. And if you remember, going back in 2016, Morrison came up and said that there was going to be no age-based limit, not age-based limits, no work limits up to age 75, and then they knocked that on the head, which I think was a terrible shame, given the fact there's only like 25,000 and 100,000 NCC or 25,000 concessional. But we'll certainly be going for that. But the main thing is, if they're living off their assessable or their non-assessable exempt income or non-exempt income from an SMSF by way of lump sum or pensions, then we can get an employment agreement or personal contribution going in. And then I've got the figures to show that you can effectively pay up to $75,000 as a super contribution on their behalf and not have to pay any personal income tax. Now, that's courtesy of a 15% tax offset for the add back of the $50,000 of assessable income to the members' tax. But remember, they're not paying tax anywhere, so it just comes there. But there's a 15% tax offset, which equates to the tax liability after LITO and LIMTO or LIMTO, whatever it is. Sounds, anyway, I won't go into that. So when we have a look at that, that's certainly a great strategy for us. Again, a utilisation of the family trust and the family SMSF. We do have to watch out, though, a $75,000 concessional contribution, either personal or a mix of personal and trust as an employment or just employment, effectively means that it will be accessible inside the fund. So again, the best time to do it is actually now, or prepare for it now, such that any imputation credits or investment imputation credits or early stage innovation companies where you get a 20% tax offset. So that's a great strategy, putting the money in now, investing in ESIC, knowing that you're getting rid of the not only contributions tax because you get a 20% offset, you get an additional 5%. As I said, we go through that. The personal income tax plan works for wonders, and I'll just go through the last one: strategies, issues, and traps. If you don't distribute the taxable income, then it's taxed at 45%. You would have heard I did quite a big session, both myself and also with Tim Munro, Change Accountants. We had a video that essentially that if you didn't have your trust distribution minutes done by 30 June, I've certainly done mine, that effectively any income that is not distributed is locked into the trust and taxed at 45%. So this is, again, one of those things that I know a lot of accountants simply tell the client to fill in one of these trust distribution minutes, but they're extremely sophisticated, and you guys really need to be doing that. Whether the client's going to pay you, so you've got two issues: is the client pays you to do those trust distribution minutes, or you seek a full indemnity from the client of any action the trustee or may face in terms of paying excess or paying 45% tax by the ATO. Again, when you provide strategies to a client, you either provide, they take up at the cost, or you give an indemnity, or they need to give an indemnity to you in relation to that strategy. Distributions from a discretionary trust to an SMSF are non-arm's length income under the NALI rules. So they're taxed at 45%, but they're not a contribution. So they're simply fund income. And so with the fund income, they go into the pool or wherever they go. So I don't think we go into separate investment strategies. There would generally be a general pool. And again, of course, we can stream capital gains in there. And if it's a capital gain, then we get a 33% discount. We could potentially stream franked dividends in there. And again, it's the same sort of thing. Franked dividends, would the commissioner have a bit of an argument for that? Well, not sure. But it is, look, they're paying tax at 45% on the distribution. but it will come out with franking credits. So you just got to watch out, because the gross up will be 45%, but your credit, you're going to get 30%. So it's probably do your figures and work out how to do that. The main thing is it's not a contribution. So it could go into the fund and be sought out for all members of the fund, irrespective of age. As I said, where distributions are made to children or other family members, I've seen a couple of instances in the last year where trustees of the fund have been sued by children of the appointor who has distributed to the adult child, so we're not talking about children under 18, distribute to the adult child in order to use their marginal tax rate, but that distribution has never been paid, notwithstanding it's been included in that adult child's taxable income. And there's been recovery action sought by lawyers on behalf of the children of the appointor. So I've seen a couple of cases of those, and they're quite significant, 150, and I saw one that was about, $350,000. So you've got to be really careful about that. One of the ones I'm doing at the moment is the next thing I've got to do, an indemnity document, TGA legal, and also a deed of gift, which my partner Tony Anamoulis is doing, so that will come up on the platform, and so that if there is these distributions, then we need to make sure that the adult beneficiary is aware of them, and there's a deed of gift, so that money is being gifted back to the family trust. So I think we've got to make sure that's in place, otherwise it does leave exposure for us. Another thing is currently building out a general purpose loan agreement, which will come with personal guarantees or mortgage deeds. You'll be able to choose whatever you want. Div 7A loan agreements, and if you're looking for the 25-year term, because you've got security, that will come with a mortgage deed. And of course, we're having a standalone personal guarantee and mortgage deed. So that'll be up and running, and I will probably do that next week. So there are really good, a whole suite of documents there that will be available for you. As you can see, we're obviously not just about SMSFs, we're about a whole range of tax, legal, and also SMSF and superannuation documents. For those of you who might not have heard, we've got a capital raising currently, so that's well and truly underway. We've got a lot of money which is getting committed. In fact, we've got quite a bit of interest from the big end of town. And go through, have a look at our offer document. I'll be doing a separate video on that later on. But with the capital raising, we're enhancing our platform. Obviously, getting next week, I think, or in the next couple of weeks, our companies will integrate with CAS 360. So I'll actually be able to put documents on there, so on and so forth. But that's not really a big issue. From us is that capital raising will further enhance our platform. We've got a lot of interest overseas as well. But we essentially, what you can see with the pricing, I mean, if we've got a three partner firm, we generally find that they'll be spending, or they'll have disbursements of, potentially, $100,000, $150,000 on documents for a year. And if they did, as I said, do more documents and less in order to ensure compliance, it should be up around about $300,000. But quite easily, that's for them, it's best to just jump on our $795 package and get all CPD for the firm in the specialist SMSF section, plus also unlimited documents. So, and even just for one partner firm, it's worthwhile. But that capital raising is worthwhile, and there's a discount there to you on the unlimited docs package, or the unlimited docs of $100 per month. So it actually pays off itself over 2 years. So have a good look at that. I think if you go to Funsition, it's LightYear, but I'll send after this video to you anyway. Anyway, let's get out of this and get straight into the LightYear platform. Now, you'll see here, Zoomtopia. I don't think I'll be going to that, although I do love Zoom. Great big fan of that. So this is the opening page. I've logged in as LightYear Docs demo there. You can see there that I've got credits. So that, for example, that means that I'm an LY basic package. If you've got unlimited documents, you're not going to see credits there, because you can obviously just do as many documents as you want. I can either search in here for the relevant document, for example, a discretionary trust. So if I do that, you'll just see it'll pop up. I've got discretionary trust distribution minutes, which I showed change of trustee for discretionary trust. If you want to go from individuals to a corporate, a leading member discretionary trust, which I'll talk about, and then we've got our standard discretionary trust, which we're going to work at today. Now, if we go down there, so we can either do that. Alternatively, go and have a look here at what you get from the thing. If you want your decision tool, whether you're going to be better off or worse off, just have a look at that. And our full document listing, just going there, that's a PDF. And there's obviously a lot more to come. We've got our strategy automation. Next week, we'll be releasing, gosh, I forgot about the loan agreements. Next week, I'm actually releasing the LRBAs for shares because that's pretty crucial for imputation. So I'll probably do the loan suite probably the week after next. So I'll get them up and running next week, but give me a couple of weeks on that one. But next week is a really super duper one if you're looking at transferring shares into an SMSF from a family trust, bucket company, etc. A bucket company, watch out for that one. That's pretty not an out there strategy, but a great strategy. And we're doing it under an LRBA because we obviously own the shares. We want to make a contribution. So in part, we get a tax deduction for it. And then obviously we'll have a LRBA to make sure we're under a 50% LVR for shares. So it's like building your own installment warrants, but I prefer to use it as LRBA so that effectively it's not treated as a derivative per se. We've got business and commercial agreements. That's where the loan agreements, employment agreements will be, and you've got partnerships, income streams, companies, borrowing, and we've got our trusts here. I've got you might have seen the superannuation unrelated investment trust we did a while ago. Addition to designated beneficiaries, that's just a quirky little one. We've had a few people saying, look, we've got a trust and simply what we've got is designated primary beneficiaries. You want to add our children to it because they're adults and so on and so forth. So we've got that one. Got a standard discretionary trust, which we'll look at, change of trustee, discretionary trust distribution methods, and leading member, which I'll come back and look at a little bit later with you, Amesh. I'll have to do that at a separate place. So we've got our general information there about the trust. It's subject to the rules of perpetuities. If you choose South Australian law, then the rule of perpetuities doesn't apply. Otherwise, it's an 80 years. More importantly, here we've got all the benefits, and I think I've already covered all of those with you here. And frequently asked legal questions: who gives sign off? Why use the document? So on and so forth. So I go in and buy the document. If you obviously here, if you're on unlimited, you don't buy it; it just pops up for you. I need to put a client's name in the vault, so I'll just use the Abbott-Family here, and I'll create a new family trust. T's and C's there in terms of the document. We've also got, if you need to get our legal advice letter, that by completing this, it isn't giving legal professional advice. It doesn't breach the Legal Professions Act. So if you want that, just contact us at support@lightyeardocs.com.au. So I can either pay by credit, again, it's only $99, or because I've already got credit up here, I can accept and pay by credit. So although it's $99, if you want to prepay, we can give you a discount on that. So what we're doing now is this is now going into our Hot Docs platform. You've probably heard of me talk about Hot Docs quite a number of times, but effectively Hot Docs is the world's leading document creation and precedent creation platform for lawyers. And there's more than 1 million users, umpteen legal firms around the world who build quite complex documents. For example, over in the UK, child support custody cases, which create, I think, about 35 or 40 documents in a line, use Hot Docs, and it shaves more than 3 or 4 days of work from that, preparing that sort of case. So again, you've got the best of the best actually sitting on your desktop. It's cost us quite a lot to create this, and a lot of R&D in order to build it and make it available for you guys. Because generally, it's an in-house product. As I said, it's 1 million users. There's estimated 10 million documents an hour created on this platform. So we just go in and we work out our name of the trust. I'll call it the Giles Abbott Family Trust. So Giles is my middle name, and actually was my great-great-grandfather who came out to Buffalo. He was an original settler. When will the trustee be created? So let's say it's from the 1st of August. Select the state, go for South Australia, and you can put in if it's wound up, and obviously in South Australia, there's the rule against perpetuities doesn't apply, so it carries on ad infinitum. But if you want to, if it's chosen to wind up, then we can put in our charity there. So let's put the RSPCA of South Australia. So that would be the wind up there. Again, these are just little tweaks that you can add for your client. So you can see the bottom line there, the red line is how close we are to completing the actual document. So then we go in and we have a look at the set law. Now, generally the set law would be yourself or whoever's creating. So the set law isn't a beneficiary, it's not the appointor. So essentially what we want to do there is we want to ensure that you provide the settlement, and then we'll go through and do that. So, for example, we'll call it, there we go, we'll call it John Smith, and he's from 100 Perry Street. I wish I could type a bit quicker, but anyway, and a bit more accurately. I've seen other people do this, and they just rip through the system. So it is very efficient if you know how to type. So obviously that's in South Australia, and the postcode would be 5,000 for that. So what's the settlement? You can put anything there. It just goes to the thing. So it's $10. So if you do that, effectively what happens is just give your client a $10 note or a $5 note, and that's settled. Mainly because a trust itself, it cannot be established unless you can't actually set it up unless there's property. So it's property first that goes into the trust, and that's the old common law. So it's, for example, I can't give my car to you to trust it unless, if I don't give my car, then how can you be the trustee of my car? So effectively, we need to put property in, and that's what you're doing through that settlement process. And generally, it's the accountant that provides that. There's no legal liability, etc. So we can put the trustee's details in. We can have a company or an individual. It doesn't make any difference. Unlike a SMSF, we don't need to have two individuals, but we can't just have one primary beneficiary and one trustee being one and the same. Primarily because that wouldn't be a trust. You can't be a trustee of yourself. Like, I can't give my car to myself to be looked after and have that trust relationship. So let's just go through a company. Now, you may well have done a company on our platform, and one of the automations that we'll be coming up with a little bit later on will be establishing a trustee company, and then that feeding directly into the family trust and potentially into a bucket company. But that is certainly on the cards. So what we'll do is we'll do the Abbott trustee. Proprietary limit is already included in there. We need to have the ACN, so we need to set that up first. So first I'm actually carrying on typing. So company registration, we have a look at 11 Old Coach Road, Burbrain. That's my mum's address. Good old mum. She's a trooper. 5. I forget what it is. 5464. I'm not sure. I'd have to go back and check anyway. Sole director. So I can be a sole director in this one, or alternatively, I can have a couple of directors. Or 2 or 3 or 4, whatever you put in there. So I'll put my full name. And that's Grant Giles Abbott. That's my full name if you don't know. And we go through, again, it's generally, if you've been on these things before, it's generally pretty good to have Ash here because she's a much faster typer. So I will go as the appointor. Now, the appointor is the person who actually has the ability to appoint and remove the trustee. So it's a very, very powerful position to have, obviously, and you've got to make sure that you not only have the appointor for, now I remember, Erbray, South Australia, it's 5064. So sorry about that. Now I can go back and obviously change that. 5464, that's coming up here to the Sunshine Coast. So we go to 5064. In the event of the death or incapacity of the first appointor, do you wish to automatically appoint the second appointor? So I would go yes. So this gives me a chain. So the problem is if I lose capacity, who is going to actually appoint the next trustee? And we can find that in the trustee, the relevant rules of the trustee. But it's better to have a second appointor, and generally it's going to be someone of the family. So what I would do here is I would put my daughter, Sophia, who's now 21, has actually got a very smart head on her brain, and asked me lots of questions. In fact, she was asking me lots and lots of questions about The Big Short, and it was, well, how do they actually get away with that? I'll just make up things. Kilda Code. So she's in Melbourne. So it's Victoria. And I'm not sure what that is. I'll just put 320. So sorry about that. I'd have to find out. And if we wanted to, we could then go down to the third appointor. So I could go to, for example, my brother, Chris. Most of you guys know Chris Abbott, and he is in 11 Surf Avenue, Manly, New South Wales. I've got no idea about what the postcode is there. Again, you can come back and change these all as you see fit. So I'll put that. So that's the appointors. So we've done the settlor, we've done the appointor. Now what we do is go through the various beneficiaries. Are there any primary beneficiaries an individual? Yes. Are there any beneficiaries a company? Yes. Are any of the primary beneficiaries an incorporated association? So if we want to do that, that could be, for example, a charity. Now we need to complete all of these as we see fit. So what we do is we go to the next and it will pop up the primary beneficiaries. So when I do that, I'll put, again, Grant Abbott. So this is named in the document, not necessarily the schedule. Now, because I've been named before, I've got a little saving there so I can put that in there, select, and that will pop up. We've got the witness's full name if we want, so I'll just put John Smith, so you can act as a witness. Add an individual beneficiary, so I'll put in there my daughter, Sophia Abbott. I won't put my other daughter, Tiana, mainly because she is, let's see if I've got that, Sophia, perfect. So I'll put that in. I won't put Tiana because she's under 18 and hasn't got capacity. Oops, so that didn't work. I'll have to tweak that. So I think she was 12 St Kilda Road. That's in St Kilda. Again, I'll check on that select. So it should actually fix up. I'll go through after that. So, and then that is 30, what was it, 24 or 25. Witness full name again, John Smith. So now we're doing our bucket company. Wherever we have individuals, again, I'm not a great fan. I don't mind digital signatures, but this sort of stuff I prefer to have actual wet signatures. So we're now going to call it the Abbott bucket, or for those who've been ever seen Keeping Up Appearances, it's bouquet. So 435, 456, 789. Street address, we'll go back and we'll choose the Erbray one. And then we go on and that's it. So that's my trustee. So it took, honestly, if you guys are a bit more adept at your typing, you would do it in a lot quicker time. But what did they take me? Around about 10 minutes. So what we're doing is we're going to go in and have a look at the document. The document will then be loaded up onto your Vault. And while that's happening, I've got a few questions. So let's go back here, Umesh. Considering the discretionary trusts in New South Wales do not have a threshold, is there a mechanism to reduce this by discretionary trust owning proprietary company, which then holds the property? I'm presuming that's a land tax issue. I might take that on advisement, Umesh. If you'd like to send me an email to grant@ilovesmsf.com, just to remind me, and then what I can do is I'll look at that in terms of the grouping elements around land tax. I certainly know for SMSFs, it's A-OK, so I'll have a look at that. And we've got, oh gosh, you've gone to town on this. Can a bucket company be a pointer to a family trust? Absolutely. So it can be the appointor if you want, but you're going to have to watch out who the directors of the bucket company are, and more importantly, who the shareholders are. Because what will happen is that in the event of the death of one of the shareholders, that appointorship, remember, the shareholders generally have the capacity to act as directors and really control the whole appointorship. So you've just got to be really careful around that one. I prefer to be more along the bloodline, the succession, and passing it down from generation to generation. Is there a way to release franking credits locked up in a bucket company, especially if the children are on a high tax bracket? So unfortunately, with the shareholders, they're just going to be stuck with the shares. But come and listen to me next week when I go through potentially transferring shares in a bucket company into an SMSF. And again, you're going down the right track, Umesh. I would say that one of the keys is when we do a bucket company, it's probably going to be the hardest thing out of all, because of we've got members under a high tax bracket that effectively we've got to be careful about obviously paying frank dividends. So we tend to shelve everything into the bucket company. But at some point in time, the piper has to play its tune and or has to be paid, and it means that that money has to come out of the bucket company one way, shape, or form. One of my big loves is obviously using the bucket company as a related party loan in terms of a LRBA. But I'll look at that again next week. Your bloodline trust is really giving power to only one person, or Prince Charles, rather than giving equal power to Charles and Andrew. This way, children of Andrew are also looked after. You'll find when we go down, it's the actual control. If we look at the leading member, so it's not a bloodline trust, it's the leading member. What happens there is the leading member has control and can appoint and remove. So because they're just like an appointor. And what will happen, though, is they've got power to veto any decision made by the trustee, so on and so forth. So they're given a lot of power, but that doesn't mean the principal beneficiaries are not included, or the further beneficiaries are not included in that whole process. So that should be A-OK. Final one we've got here is the proposed deed of gift. So that's from Liam Dunn. Is the proposed deed of gift all fine under the discretionary trust reimbursement agreement provisions? I won't know you'd ask me a pretty typical or tough one there. Let me have a look at that, Liam. I'll be doing the deed of gift next week, and I'll go and have a look at that reimbursement agreement provisions. I must admit, I'm going to have to do a bit of research on the actual specific instances in the Income Tax Assessment Act to cover that one. Another one from Umesh. If a minor is employed for 2 hours, paid 50K in SMSF excess contributions, gets assessed in minor's hands at normal rate or penalty rates. In order to make a contribution, actually we don't need to do that. So I'd probably get them working more than 2 hours, but essentially have a look at, I think it's TR 2005/8. But I'm going to have to go through Umesh and I'll work on that next week, because we do add it back to assessable income, but my gut feel is that the penalty rates only apply from distributions from a trust. This is actually added back from super as a contribution. So I am going to have to go back. I think it's actually at the normal rates. But what I'll do is I'll do a bit of research, and for those of you who are on this webinar, I'll make sure I'll come back and just give me a day or two, and I'll cover both of these questions as well. Umesh, can you add a bucket company later on? Absolutely. So remember where we had in the documentation, add a specified beneficiary. So you use that documentation there as well. Land tax I'll have a look at. Neil Pitt, what if the trustee company name ends with proprietary limited and not PTY limited? Is there a way to change this? Let me look at that with the in fact, if there is, I might actually change PTY limited for our companies. If this is a common issue, Neil, can you just send me an email, or actually to support@lightyeardocs.com.au, and we might use that as a default. So that might be better. In fact, yeah, look, I think that might be a good issue. So if you could send that to me, and also Mesh, send me the issue around land tax. That'd be great. So I've got to do a bit of research and come back to you. So I love these sessions because I get as much out of these sessions as you guys, because the more that comes in, the more strategies I get to think of. So we can download the document. As I said, it'll sit up on the vault. You have got, at this stage, 24 hours to make any changes, particularly if you've got fat thumbs and you're going in and doing different, you've got the wrong postcodes or the wrong ACNs, etc. But I'll open, this will pop up as a PDF. We are looking at extending that. I'll have a chat with our team a little bit later on, so it can be open for a while. For unlimited document users, if you make a huge stuff up, doesn't make any difference. Just guess what? Just go in and start again. So I've got my PDF open here. So this is the actual discretionary trust that we've got here. So let's go and have a look at the discretionary trust. Oops, sorry, I had it down here. So it's popping up. I think I actually closed out of the page, so sorry about that. I was just changing all the little stuff that's on my screen in order to do that. So I'm going to open. I can save it if I want, but remember it's saved inside your vault up on the screen anyway. So I'm downloading. Here we go. So you've got the discretionary trust deed. For those of you who are our licensees, what I would encourage for some of you, we talked about our so much per month, but we do have 5-year unlimited licensees and training and marketing from myself, which is guaranteed for 5 years for a flat fee of $25,000. So if you want to do that license, then you can actually put your logo up there. So a discretionary trust deed, it's prepared and signed off by TGA Legal. We go down the document index, as you can see here, prepared by TGA Legal. We've got our document last updated 1st of July, so it's super, super fresh. We go through the deed of trust. We get the set law, which is John Smith. We've got the trustee there. Remember, we had the Abbott trustee as trustee for the Giles Abbott Family Trust. The recitals, the settler wishes to create a settlement to provide benefits for those who are named, etc. Trustees agreed to act as first trustee. The terms upon the settlement are set out in this deed. So we've got the definitions, and we've also got the interpretation here. We've got the employer, which is Grant Giles. In the case of incapacity or death of this person, the next in line is Sophia Abbott. In the case of incapacity of that, it then goes to Chris. So we've actually got a really good succession clauses sitting in there. We've also got beneficiaries there who may be entitled to income or capital. We've got the child, we've got default beneficiary, grandchild, great-grandchild, the income, so on and so forth. You've got the primary beneficiaries. I will be doing, we've had a couple of requests to actually put that in a schedule. So we'll be doing that in the schedule a little bit later on. What I'll be doing there is we've got the 2 primary beneficiaries, but that will actually be sitting in a schedule with the settlor, etc. So you don't need to have a look through that. So they're the primary beneficiaries, and we'll go through. We've got the establishment of the trust. The beneficiary should comprise a primary beneficiary, which is defined up there. Any child, grandchild, or great-grandchild of the primary beneficiary. any other relative of the beneficiary born before the termination date, and also obviously the company. Umesh, you can add that at a later stage when we increase our designated beneficiary. We can add a secondary trust, so the trustee or any trustees of any trust, whether new, existing, or hereafter created, of which a beneficiary or discretionary object hereafter is a beneficiary of the trust, and obviously a charitable trust. Additional beneficiaries and default beneficiaries, and then we've got a whole lot around there. So that's really everyone can be included in that. Income of the trust fund. Have a look at this. If you need a copy of this deed, please feel free to contact us at support at lightyeardocs.com.au, and we'll go through that. Trustees shall stand possessed of the income of the trust fund of the financial year, which is available, and obviously there's a payment has to be paid out before 30 June. So the trustee may accumulate it at any point in time and pay tax on that. So you need to have that measure inside the deed in order that if it does decide to accumulate, and it may be that everyone's tax rate is over is at the top margin rate, so therefore you are accumulating at a 45% rate, so you're saving yourself the Medicare levy and NDIS. The manner of allocation we've got there. We've got for ones who are not under a legal disability and the ones who are under a legal disability, basically sitting in there. We've got payments, etc. So have a look through that. The effect on the trustee. I want to go through the method of allocation. You've got plenty of stuff that's sitting in there. We've got the distribution of capital. Again, we can have any of the primary beneficiary or anyone else there being the corpus, which would sit in there. But the determination of the trustee, the manner, except this is all the capital. No resulting trust there, so that's important. For example, that if we do make a distribution, it doesn't mean that there's a separate trust that is created. So that's absolutely crucial. The categories of income, which is probably the most crucial. This is the Bamford area there. So the trustee may, in the books of the account and records of the account, separately record each of the following categories of income received in the fund, and these can be distributed. Dividends, which are fully franked, unfranked, a foreign tax dividend if you want, any other separately identifiable tax consequences of benefit. So you can do those, and each one of those can be streamed quite separately. So, for example, we can stream unfranked dividends to a retiree if we want. But generally, we might want to actually stream it to retiree franked dividends so they can get that tax-free money, which is the refund of franking credits. Income, including capital gains, which has an Australian source, foreign tax source, is exempt or not liable to be taxed, or has any other separate identifiable consequences. The trustee may identify, separately record, and maintain in the books of accounts income or capital having, in respect of which there is attached individual or unique characteristics other than it's referred to. So there might be something else that's sitting in there that has unique characteristics, and we can put it in there. So the deed is actually pretty broad. The trustee expenses and outgoings may at the discretion of the trustee be allocated against and deducted from income or capital of any one or more categories. So again, this fits in all with Bamford. In fact, the guy who drafted this is the person who took Bamford to the High Court. So make sure you have a look at it. I won't go through all of this. Appointment and removal of trustee, again, is the appointor, again, which is why we have the succession. I would say, Umesh, remember you talked about the bucket company being appointor. Look, because of estate planning and also divorce issues, the last thing, can you imagine if the bucket company went to a spouse in a divorce and they suddenly controlled the family trust? You just got to be really careful about that. That's why I like that succession we've got there. Keep it in the family, keep it in the bloodline or the lineage or whatever you want to do. Again, we can have more trustees, remuneration. Really, the rest is pretty stock standard. Unfettered power, vacation of office, custodian, investment powers. As you can imagine there, we've got unlimited investment powers. We've noted all those down. Property development, carry on businesses. You've got the general powers, etc. We can make distributions. So most of that is pretty stock standard. We should have, I think, wind-ups coming down the track. As you can see, there's a lot of stuff in there. We've got a lot in there. Power to act as a director. Amendments. So again, Umesh, if you want to put it in, you do the amendment by that designated beneficiaries. Follow that process. We've got all our accounts, notices, and then we've got winding up the trust. So we can either go through 80 years or obviously because it's Adelaide, it's perpetual. And then you'll find there, if we got there is, if it's going to be wound up, and go to our charitable entity. And there's, of course, if it's executed by the parties, the set law, we've got the witness there, the trustee there, because it's a company, then we don't need to have a witness because it's signed under Section 127 of the Corps Act. And then that's it. We don't need to get the primary beneficiaries or anyone to sign. So there's a lot of stuff in there. If you've got any questions around that, please feel free to give me a hoy. I did quite a lengthy session on SMSF yesterday with Milton Shaw and also Ian Feldberger, both shareholders, and we went through a few issues around the SMSF. So just because we've got a document now doesn't mean it's not going to get better and updated, which is essentially what this whole process is about. It's a sharing community. The more feedback you get, if I see it's a great option to fix it up, then we'll do that. So I think I've answered all the questions. If not, another Umesh. Umesh, if you want to come to me. So if you're asking a technical question, the best person to go to is Grant at ilovesmsf.com. If you want to get, so it's Grant at ilovesmsf.com. If you want to get a special super deal or want to have a look around the site, get a demo of all the sites, but I think you've seen enough here now. We want to sign up. You can either sign up directly on the site, or as I said, if you're putting in I think our minimum investment is $3,000 into our capital raising, have a look at that. That will now drop down your fees. If you're just going to take documents only, it's $4.95 a month, which is, that's ridiculous. Some people charge that just for one deed, and that's unlimited documents. But I'd go for the documents and CPD, and also tech support, strategy support from me. That's $6.95. So if you want to do that, get a special deal, and it's even more special deal if you want to pay for a year up front. So contact Daniel at ilovesmsf.com. So it's Daniel at ilovesmsf.com. Any issues around the site, how it can be fixed, how it can be improved, or documents, then simply go to, if you want to go to support at ilovesmsf.com or support at lightyeardocs.com. I wish I could give you a CPD point here, which to me, we've really just gone through technical issues and a lot of training around that, but unfortunately, I don't, in fact, I might be able to give you a FASEA CPD point. I won't be able to give you SMSF Association. FPA might be able to give you, but definitely I think I might be able to do a FASEA CPD point because we are going into some pretty hardcore law. So let me think about that one and come back. If that's the case, then you're getting even more CPD hours under the FASEA guidelines. See what happens. I come up with some ideas as we go down the track. Anyway, this will be recorded and I'll send out an email on this a little bit later on. And a couple of those questions from Umesh and also Liam, I will come back to you later. Anyway, it's Grant Abbott signing off and thank you very much.